Your Lordship, I beg to mention item number 6.
Item number 6.
Yes, Your Lordship.
Hmm.
May be listed after Bihu break. May be listed after Bihu break.
Why?
Actually, main council is out of station.
Okay. On the prayer of MS,
Sonam Somu.
you are appearing for ESMO.
Yes, Your Lordship.
MS on the prayer of Miss so and council appearing on behalf of Mr. Esmo. List this matter after Bihu vacation.
Much obliged.
Yeah, please, Lordship.
Yes.
Lordship, this appeal by district Raman.
Hmm.
Impugn order is a page, Lordship.
What is IA? IA disposed of
I for
condemnation of delay. IA is for what?
two I was filed. One
Ah.
was for condemnation for delay.
IA 85.
Delay, I think that is not disposed of.
Okay.
And another one is for issue of the impugn order.
IA 85. IA 85. Don't list it. Dispose of once. Then 84 is
84 is Lordship for delay loss.
what is it? What is 85?
84 is the delay losses.
And 85?
85 is for the suspension of the.
That has also been disposed of. Hmm?
That is not yet the.
Then IA 84 disposed of. Then IA, what is to be done today? IA 85.
Matter can be hard Lordship if my friend is ready.
Yes,
Matter, my lord, can be taken up for disposal, my lord.
yes.
Impugn order is it page Lordship. That is 1-3 Lord, 13. 1-3 13 Lord. Here the brief case is Lordship. The petitioner is working as a Lordship Lensnaik in first IRBN Lordship, APPBN Lordship. And he encroached over the Lordship, the lane allotted to the very department, it's APPBN Lordship.
Yes.
So disciplinary proceeding was Lordship drawn against him Lordship. And initially Lordship, two increment was reduced. But in revision, it has been lessened down to Lordship 1 increment, reductions of 1 increment. And appeal against that very order Lordship, this petition was filed Lordship.
Yes.
Where Lordship this present impugn order has been passed. Kindly come to page 13 Lordship.
13.
13.
1-3.
1-3. This is the impugn order. Then kindly come to page 16 Lordship, the relevant portion. Para 6 Lordship.
Yes.
I have considered the submissions of both the learned counsels. A person cannot be held guilty of having committed an offense which does not exist. It is admitted fact that the section 6 rules, two of CSS conduct rules does not exist. For that reason, the charge against the accused cannot stand. Since the charge has no basis, the punishment or sentence given against the petitioner also cannot stay because it would have no basis to stand. For the regions, for the aforesaid regions, I find that the impugn order so and so passed by so and so is illegal and accordingly same is quest and set aside, Lordship.
Yes.
Now,
Para 5.
coming to the Lordship, there is that order, Lordship.
Page 16. You read para 5.
Yeah. Mr. Well, so and so submit that though it's an admitted fact that the provisions of law mentioned in the impugned order is non-existent law, but the fact remains that the petitioner has been under occupations of a plot of land allotted to past IRBN. Therefore, the sentence or punishment given in the impugned order should stand. Here, Lordship, that was the Lordship submission on our part, Lordship. If Lordship say the impugned order in the writ petition, impugned order in the writ petitions may take Lordship to the additional affidavit filed by me, Lordship. Because the inter documents pertaining to two departmental proceedings in sequence has been given in the additional affidavit, Lordship.
Of course, it's a continuation of writ proceedings. But you should consider first the writ petition as well as your stand in the writ proceedings, not the additional affidavit.
No, additional affidavit is a part of this.
Yes.
Yes.
Part of what?
Part of this appeal only, Lordship.
You have filed the state of
Additional-
appeal.
Correct, Lordship.
Yes.
Additional affidavit has been filed in appeal only, Lordship.
Yes.
Bringing on records, Lordship, the two departmental records pertaining to two departmental proceedings.
Is it your case that this was you could not place all these documents?
Those are not the new documents actually, Lordship. Some
Yes.
of them. They are connected to this very
All are new documents or all documents which was considered before the learned single judge?
Lordship, it was before what happened here, Lordship. While annexing the Lordship, the documents pertaining to departmental proceeding, Lordship. Petitioner, because writ petition was filed by the present respondent, Lordship, they annex some from the past proceeding and some from the second proceeding, Lordship. Which are making confusion, Lordship.
So you are not allowed to file the detailed affidavit before the learned single judge.
Lordship, we have filed our affidavit.
Then why you are blaming the
No,
petition?
I am not blaming anyone, Lordship. What I'm submitting is, Lordship, what records I have brought in Lordship, that is pertaining to the departmental proceeding, Lordship.
Yes.
There's no dispute on that, Lordship.
Yes.
There's no dispute on that, Lordship. There's a part of the records only.
Yes.
And that will
Was
not,
the record produced before the learned single judge?
Lordship, no, it was not.
Anyway, what is your ground? Plus,
Lordship,
you said
Lordship.
it is admittedly non-existent law. The provisions which you have punished or you impose a penalty,
Lordship.
it's non-existent law.
Lordship, that has been explained in our affidavit, Lordship.
What affidavit?
Our affidavit, state affidavit filed by the state government in the repression that has not been discussed by the London single bench.
Okay.
So this is one of my ground also.
Yes.
Here, whether these rules, section 6 rules 2 Lordship, 2.2, whether it exists
You
or
are saying that it's a Swami's handbook.
Lordship,
What do you mean by that? If it is not in the CCS rules,
Lordship,
which you have relied on,
Lordship.
why are not concerned about Swami's handbook?
Lordship, we have explained, Lordship, it has been mistakenly. It should have been.
Then what is the law? I mean the provisions. If it is not rules, section 6, rule 2, Roman 2 of CCS conduct rules 1965.
Lordship.
What is the rule? What is the provisions?
Provision is.
Relevant provision. We have seen it. It's a Swami's handbook.
Correct, Lordship. It has been referred.
Why not relying Swami's handbook?
Lordship,
If it is not there under the CCS rules, which you have relied,
Lordship.
so are CCS rules. Let us assuming this is a wrong quoting of the provisions.
Lordship. Lordship,
What
we
is
have-
the exact rule
in
or
CCS
the relevant rule?
CCS rules, Lordship,
Yes,
the Central Service Conduct Rules
yes,
1964 Lordship.
yes.
In Lordship, section 3 Lordship, rule 3 Lordship. Here, every government servant shall at all times do nothing which is unbecoming of a government servant, Lordship.
Here it is.
Lordship,
Again, his Swami's compilation. Compilation we understand, but it has been compiled. This is rules. Now you are saying that you have quoted the wrong provision of CCS rules. But then it is the rule 6 of Swami's handbook. Where is the Swami's handbook rule? The Swami's handbook has a different rule, which is the statutory ruls.
no.
Or is it created by Mr. Swami?
It's a creations of the Mr. Swami only, Lordship. By
It's
way
a
of
compilation.
compiling, Lordship.
You are relying on a Swami's handbook. It is a compilation of the CCS rules. So what's the
No.
rules, relevant rules?
Lordship, kindly come to this conduct rules, 1964, Lordship.
CCS rules, classification, control and appeal, 1965.
This is the conduct rules, 1964, Lordship.
What 60? Conduct rules.
Lordship. Rule 3, Lordship.
Just wait. It's conduct rule. Have you got it? Have you got the conduct rule? Show me. Conduct rules. Sentences of conduct rules. Yes,
Lordship,
where it is?
if
Swami.
Lordship is rule 3, Lordship. General Lordship. Here, Lordship, the rule 3, every government servant shall at all times maintain absolute integrity, Lordship, and then maintain devotion to duty and do nothing which is unbecoming of a government servant, Lordship. Here, the issue is, Lordship, then, Lordship, kindly come to, I think, same thesis rules. Or here, Lordship, the government of India orders, Lordship. Here, Lordship, act and conduct which amount to misconduct, Lordship.
Where it is?
Page 332, Lordship. If Lordship,
We're having a different book. This one, white one,
Lordship, kindly see that.
3.
It comes under, Lordship, the rule, general rule 3 only, Lordship.
300.
No, page, this is 319, Lordship.
Hmm.
Then 322, Lordship. 322, Lordship.
22.
Here, Lordship, acts and conduct which amount to misconduct, Lordship.
$322.
Lordship.
No. You are not getting anything.
I think the page book is a bit different.
Different.
Page must be different.
General rules number.
Anyway, Lordship, may I take Lordship to the Swami's handbook lawsuit. This is a compilation only lawsuit.
Okay.
Swami's handbook lawsuit. Finally, come to general rule 3 lawsuit, definitions, and then rule 3 lawsuit. At page 8 lawsuit. Rule 3.
Page 8.
Page 8 lawsuit. This is the same definition of general rule 3 lawsuit.
Yes.
Here, every government servant shall at all times lawsuit. It's given there lawsuit. Maintain absolute integrity, maintain devotion on duty, and do nothing which is unbecoming of a government servant.
Yes.
Commit himself to and uphold the supremacy, so and so and so. Then I'm taking lawsuit to the uh, 18 lawsuit. 18.
So you're relying on rule 3.
Rule 3,
Sub-rule.
this is also part of the CSS rules only. This, as lawsuit, as observed lawsuit, this is compilation only lawsuit. What I'm trying to point out is lawsuit.
Page 18. Page 18. 1-8.
No, sir.
Here lawsuit, it's page
Page
8 lawsuit.
Page 9.
Page, yes. Yes, we have seen this. Rule 3, we have seen it.
Lawsuit.
Then next.
This is the lawsuit. What I'm submitting is lawsuit. Here lawsuit, the issue is encroachment of one's own employer's lane lawsuit. Whether it's amount to lawsuit, misconduct or not lawsuit. That's the issue here lawsuit. Here lawsuit,
Is there any proof of encroachment?
lawsuit. I'm coming to that. I'm coming to that.
If you are coming to then next.
Then by referring lawsuit, this ceases conduct rules lawsuit. Yes, I just
Rule 3, all rule 3.
In rule 3 lawsuit, not all rule 3 lawsuit. Under rule 3,
Under rule
some
3.
conduct has been given lawsuit.
Yes, which one? Do nothing which is unbecoming of a government servant.
That's the one. That is the one lawsuit.
Then
lawsuit. Uh, 18 lawsuit. Is refrain from doing anything which is or may be contrary to any law, rules, regulations, and established practices lawsuit.
yes.
This is unbecoming of a government servant lawsuit. And
Yes.
this has been lawsuit elaborated in CSS rules itself. Here, what lawsuit? Rule 3 lawsuit. Just I'll read from CSS rules only.
Yes.
If the act or conduct is prejudicial or likely to be prejudicial to the interest of the master or to the reputations of the master, here lawsuit. If the act or conduct is inconsistent or incompatible with the due or peaceful discharge of his duty of his master, if the act or conduct of the servant makes it unsafe for the employer to retain him in service, if the act or conduct of servant is so grossly immoral that all reasonable men will say that the employee cannot be trusted. If the act or conduct of the employee is such that the master cannot rely on the faithfulness of his employee. So these all are the lawsuit, the act of the lawsuit, the petitioner comes under all these definition lawsuit.
According to you.
According to me.
I mean, according to the state.
According to this.
Yes. Then
lawsuit, how he has conducted, how he lawsuit acted which is amount to lawsuit this misconduct. Then kindly come to lawsuit there was a two proceeding lawsuit against lawsuit. The first proceeding was lawsuit what happened while constructing the highway lawsuit, that Chimpu to Holongi lawsuit. He sold the land, trees fallen down from this very lane to the highway authority. So against that,
That was not proved.
lawsuit,
That was not proved.
that was not proved, but their lawsuit,
It was taken to appeal. You have,
eh,
you did not, appellate authority did not agree to that.
correct lawsuit.
Only issue is encroachment.
Issue is encroachment lawsuit.
Yes,
But their lawsuit in that proceeding, so far encroachment is concerned, that has been lawsuit, proved lawsuit,
yes.
encroachment lawsuit. But in the second proceeding is lawsuit offshoot of the first proceeding lawsuit.
Yes,
Because in the second proceeding conclusion was that lawsuit. So for selling of tree is concerned, that's the theft of the tree lawsuit is concerned, it's not proved. Because who had exactly taken away the lawsuit, trees lawsuit, stolen tree.
that is gone. No.
But there was a lawsuit, the observation lawsuit, that the petitioner has lawsuit encroached over the land which has been allotted to the
It's an observation or a proof. You need to prove it
lawsuit
in the proceedings. Was there any departmental proceedings against the respondent?
lawsuit.
Then
That was their lawsuit.
was it proved?
Lawsuit, their lawsuit. I'm
Not beyond reasonable doubt.
may take to the second proceeding then also. Second proceeding.
Yes.
So kindly take up my additional evidence.
First, you show us whether the encroachment was proved or not in the departmental
I'm coming to
proceeding.
that only.
Number one. Number two, if it was proved, then under what provisions of law the respondent was penalized?
Kindly come to a lawsuit. Kindly take up my additional evidence.
Yes. Additional.
Additional evidence.
Was it not part of the proceeding before the learned single judge?
Lawsuit, this was not the part of.
Then you file a review petition. Yes.
But this is the part of the departmental proceeding only. Lord.
That you have given a chance to, file a response. Affidavit you have
no, sir,
filed.
that
If you have not annexed all those things,
No,
if
sir.
you have not taken all this decision,
Records can be produced by this one of a court also. Lawsuit.
it was placed before the learned single judge.
It
No.
was not lawsuit.
Then, in that case, you file a review.
But it's not disputed lawsuit.
It's disputed
Not
because this was placed before the
this is a
learned
part-
single judge.
this is part of records only.
Part of record was not placed before the learned single judge. Whose fault?
But this finding is not
Whose fault? Are you blaming the court?
lawsuit. It's not being disputed by respondent lawsuit. Kindly see, it's a part of records lawsuit. By which lawsuit he was his lawsuit he was exonerated from the lawsuit charge lawsuit. The
Yes.
past proceeding lawsuit.
Yes. Let us see.
Kindly come to page 29 lawsuit.
29.
Page 29 lawsuit.
29 of the additional affidavits.
Lawsuit.
Yes.
Lawsuit. This is the order by which lawsuit petitioner, read petitioner was exonerated from the past proceeding lawsuit.
Yes.
Page 29 lawsuit findings. During inquiry, it is found that since 1994, Lance Nayak so had encroached and occupied the land located near RP Gate, which is under possessions of first AAPBN since 1989, as per the described map and the government allotment order number so and so, dated so and so. He has admitted the occupations of land and stated that land was occupied since 1994. And he had been doing gardening and planting bamboos and other domestic things. There were 2 trees in that land between NH52A and the RP Gate. The NH52A clearing was undertaken by MSPK Engineering. Chile Krishna Mohan, civil engineer from Raja Mondri of Andhra Pradesh, was the project manager for Chimpu area. There were 2 trees, and 1 tree was cut by them and kept it near the residence of IG sir. But they were facing difficulty in cutting the other tree, as it was about in fall on the house of Sri Bamo Tape in WC Colony, Chimpu. But in the intervening night, so and so, the tree was uprooted under the supervision of Chile Krishna Mohan, the project manager. The tree blocked the road, and so he went to Biri Tabak for sewing machine or to cut the tree into pieces to clear the road. Sri went to Tuku Tayu of CWC Colony, Chimpu, who was having a sewing machine, and told him to cut the fallen tree into pieces to clear the road.
Has admitted the encroachment land which is supported by.
See, so and so and so. So last person lordship, so and so.
Yes. This is the
Last
first,
night, so and so
this is the
has
first inquiry.
first inquiry.
Yes.
Here lordship,
He has admitted
Taitaji has admitted lordship.
encroachment.
So far 3 is concerned, he said lordship, I have not sold the 3, and so far lordship, the encroachment is concerned. Taitaji has admitted the encroachment of land which is supported by land allotment also and so and map and the
Yes.
field inquiry. He has admitted lordship.
Yes.
Even his statement lordship. If lordship see statement of the petitioner lordship. There also lordship, so far 3 is concerned, he said lordship, I have not sold. And even he stated in his reply to that proceeding lordship that compensation has been taken by the police department lordship. He said land is taken by the land is belong to me, but compensation has been taken by the police department lordship.
Yes.
But in the second proceeding law, what he is stating is lordship, compensation has been drawn by me lordship. Again. So therefore lordship in the second lordship, first proceeding lordship. So for selling of tree, finding is not their lordship. Therefore he has been exonerated from the charge. But so far encroachment is concerned, it amount to lordship misconduct. Therefore, a separate proceeding may be drawn lordship. That was the lordship observations made in the first proceeding lordship. And accordingly, lordship, second proceeding was initiated lordship for encroaching over the government land. And here also lordship, witnesses were lordship examined lordship. 2 witnesses who were the part of the first proceeding lordship. And they have been cross-examined lordship. And petitioner has his statement was recorded lordship. These all things have not been denied lordship.
Where is his statement in the second proceedings?
Second proceeding lordship. It starts from lordship page 34 lordship. Page 34 onwards.
Statement, his statement.
His statement is page
Written statement
40.
is page 37.
40.
Ah.
27 is the lordship statement in the past proceeding lordship.
Yes.
Here lordship will find lordship. There's no statement pertaining to the lordship ownership or positions of this very land by the petitioner. Petitioner has not stated anything here lordship. And if lordship come to the lordship previous page, this page 39 lordship. Just previous page lordship. This is the lordship statement recorded in lordship the first proceeding lordship. Kindly see what. Here categorically lordship statement has been given lordship. While constructing the highway lordship, some portion has gone to the other side and petitioner is claiming that portion only lordship. That is the statement.
Yes.
Then lordship, then lordship kindly come to page 9 lordship.
Page 9.
Page 9 lordship. This is the reply lordship to memorandum of articles lordship. Just this is the reply filed by Taitachi, that's a read petition lordship.
Page 9 of your
My
edition. So it's, writ petition.
article number 1 lordship. Regarding the land allotment, I am not denying that past APPBN has not been allotted have a land allotment. But regarding the questions of selling of tree, I am fully denied that I am not sold any tree where the land is I occupied. Rather, I was also inquiring about the tree who has cut my tree from my occupied land. But on my inquiry, I did not found who has cut the tree. Only I presume that road constructions party has taken the tree. Therefore, I have not done any misconduct of the decision which has affected my service career lawsuit. Here, lawsuit, the petitioner has admitted lawsuit, the land is allotted to the past APPBN lawsuit. But what is that law? He occupied lawsuit.
When the APP was allotted?
89 lawsuit, 1989.
Page 10, he said it's also under the highway authority. It's not
Here,
under the possession of.
here, see, he very categorically stand has been taken by the petition lawsuit. It's allotted to the APPBN lawsuit. One lawsuit. This admitted by him. Second lawsuit, now after acquiring the land by the highway authority, either it falls under the highway authority or the land department. From any angle lawsuit, land doesn't belong to him. And if he is in possession, that's an illegal lawsuit. That's an admitted lawsuit. Now, kindly come to page 40 lawsuit. 40.
Sorry, my lord, this it is evident, my lord. He is not served to me, my lord. I believe, my lord. Now, from where, my lord, he is saying, my lord,
You said this can be disposed of. In that case, you serve it
No, my lord,
after 2 weeks.
my humble submission, that can, this is the, this can be disposed of.
Hard
My lord.
dis-
We are looking into this evidence, my lord. Because, my lord,
See-
the issue, my lord,
See, he is relying on the additional affidavit for last 20 minutes. Now you are raising that issue, saying that you have not been served. Give you I'll ask him.
No, my
we'll
lord,
ask him to.
my
attach
humble
your
son,
copy.
this, my lord, this is the part of the history, my lord, to keep pending. My humble son, even without looking this, my lord, At this stage, my lord, this, without looking this case.
Suppose,
case
see,
disposal, my lord.
Suppose impute order penalizing you or punishing you
My lord,
by quoting a wrong provisions,
My lord.
if they can establish
My
that under the provisions today also now,
that
can be accepted.
That is the true, my lord. That is the issue before petitioner.
Certain law.
That is the issue, my lord. Now, time and again, my lord, not only
That's
that
why we
impute,
wanted
by
to
the
know
impute,
whether in the departmental proceedings, whether the allegation was proved or not.
no, my lord,
At least the selling of trees, it was you have been exonerated.
exonerated, my lord.
But the enforcement on your own, the submission.
No, no,
I
my
think
lord,
it's
that is, from where, my lord, he is saying that that
So
is
only
undisputed,
we'll ask-
my lord, that is.
In that case, we'll only ask them to show us the provisions.
Yes, my lord, true. That is the
Show
only
us
issue,
the
my lord.
provision and we'll dispose of.
That is the issue, my lord, only where, my lord.
But where prima facie of the view that the enforcement has been established.
No, my lord,
It has been proved.
even if it is proved, my lord, let them show, my lord, under what provision, my lord, the penalty imposed, my lord. That, my lord,
That will determine.
on two occasions, on two
You,
petitions,
today,
my
what
lord.
do you want?
My lord.
You would like to have the additional affidavit?
No, my lord, I will argue, my lord.
You
That
don't
will be
want.
better, my lord.
You don't want.
No. Let,
It's okay then. We'll dispose it of. That's, continue. Now you show us, where is the relevant provisions of law where he can be punished? We have seen the rule 33,
Lost,
right?
lost.
Then show us the provisions. Why you have mentioned rule 6, section 6? What is the, in place of section 6, what is the relevant provisions
Lordship,
which he can be punished and impose penalty?
Lordship, that omission lordship, on our part lordship. We have a record lordship. If lordship see the order lordship, impute order in the writ petition lordship,
Yes, page
it's at page lordship 73 lordship.
73.
It's a part of the writ appeal also lordship.
Yes,
In sequence manner lordship, I have produced
73. Huh?
lordship. Because this is offshoot of the lordship order passed by this honor court lordship. In terms of the order passed by this honor court lordship, in one writ petition that is lordship, the petition number 393 of 2018 lordship. This very order has been passed lordship. And relevant is at page 74 lordship. Page 74 lordship.
It's okay. Where is that the impugn order?
This is the impugn order in the writ petition lordship.
Huh?
This is the impugn order in the writ petition lordship.
Hmm.
And here lordship, the issue of wrong quoting of the wrong provision has been referred lordship. Therefore, this has been challenged because it's here lordship, while passing this order by the authority, the wrong provision has been referred.
So that was this.
That was the issue in the
This order was set aside.
This order was set aside.
And then next, after the second proceedings, you have passed an order imposing a penalty. Where is that?
This is the second.
Huh?
This is the second proceeding, pertaining second proceeding.
Where does it say section 6 or something like that?
No, because lordship is putting queries to me lordship. Therefore, lordship, I'm taking here in dear lordship. May I take lordship to in sequence manner lordship? So that lordship inter concept is understood lordship.
We'll admit and fix for hearing.
Lordship.
My lord, that is, my lord will kindly apply this, D, my lord. Start in the year 2015, my lord.
Yes.
Now, due to this, my lord, my promotion, my lord, is pending then. This is the strategy, my lord. Now, my lord will kindly appreciate this chance, my lord, to specify the provision under which, whereby I was penalized, my lord. That was repeatedly given by, given to them time and again, my lord. by in the two read petition, my lord.
Hmm.
Now, even my lord, they have explained in the their affidavit, even second order, my lord, they did not quote any clear provision, my lord. Thereafter, my lord, affidavit opposition, my lord. It also they try to clarify, my lord.
26.
My lord will kindly turn to my lord.
Where is 26, 5/20/22?
There's a page 73.
73?
Page 73 laws.
No, it's 17 August 2015.
No. Page 17,
17.
73 of my additional affidavit laws.
No, my lord. In
And in the
additional, my lord, additional opinion, everything is here in appeal memo, my lord. I'll indicate that, my lord, at page number, my lord, 130, start from 132, my lord. Is the 132?
otherwise page 132 in the read appeal laws.
132, my lord.
132.
Now, this order, my lord, was passed, my lord, in compliance of the another order of this honorable High Court, my lord. Categorically, this honorable court give them a direction, my lord, to clarify whether any civil dispute, my lord, can be come under the misconduct, my lord. Now, thereafter this order was passed, my lord, the specific provision they quoted it is at page 133, my lord. 133, my lord. Last para, my lord. 133, my lord. Therefore, in compliance.
See, Mr. Your only contention was that you have quoted a wrong, provision which is non-existent
No,
and you
not
have been
really.
penalized.
No.
That is the finding of the learned single judge. Other issues which they have raised, it has not been considered. I think we need to consider that.
No, that is not, my lord. My lord will kindly,
See,
only, my lord, 2 page I saw, my lord. Mindly have a look at 133, my lord.
page 74, therefore, of the additional affidavit
My lord.
or that impugn order. It says the act of so and so amounts to misconduct under section 6, rule 2 of CCS conduct rules.
Yes, my lord. That,
According to him, it's rule 3 and rule not section 6.
yeah,
That's a wrong quoting of a provision.
no, my lord. That is the specific, that, my lord, is 146, my lord, page number in their affidavit opposition, my lord. That has been annexed, my lord.
See, what we could have understood, the impugned judgment and order of learned single judge is only on that issue only. No other issues has been discussed.
No, my lord. That way, my lord, kindly have a look at page number 146, my lord. Now, there is 10, my lord, they has clarified, my lord, in their affidavit opposition, my lord, after quoting
146.
146, my lord. 146, my lord. They have said, my lord, what they have said. Swami Handbook for Central Government Staff, Matswami and Birjan, yet inadvertently reflect section 6 of Rule 2(1) of CCS Conduct Rule. It is noted that the above act and conduct which amount to misconduct are invested in the clause 23 of C of the CCS Rule 1964. Now, my lord, down below, that has annexed, my lord. Now, the rule 23C, my lord, will find at page number 153 of this appeal memo, my lord. 153, my lord. 153, my lord. 153, my lord. This rule code under which, my lord, they have penalized me. They are again, my lord, after in April they have annexed these documents, my lord.
153.
53, my lord. Now, my lord will see rule, yes, my lord. 153 rule C is prohibition of sexual.
It's okay. All these are wrong quoted by the either the lawyer or the authorities. We'll consider it.
Yes, but then, my lord, my humble submission, my lord. Repeatedly 2 times, my lord. They have given us, my lord. Now, today also, my lord. My lord.
You are not challenging the learned single judge order?
No, my lord.
Respondent.
No, my lord.
Right?
No.
What was the consideration before the learned single, as per the impugned judgment and order? It says you have quoted, you have punished a man which is to an offense which is non-existent by quoting that section 6. Now they are saying that it's a wrong quotation of the provision.
My lord, then let
They are
them,
saying that section 3.
yes,
I
my
mean,
lord.
rule 3.
That is the only legal issue, my lord. My humble understanding. They don't let them, my lord. My lord will let them
So
direct.
according to prima facie, it's a wrong quotation, it's a settled provisions of law.
My lord, that's why I am saying, my lord.
The
Even
wrong quotation of the provisions of rule or the act will not vitiate any order.
yes, my lord. I do consider it. That's why, my lord, I am
If you
saying.
are considering why allowing the writ appeal.
I am saying let them quote the right provision, right today, my lord.
He has quoted, we have to consider it.
No, my lord.
It's rule 3 only, not section
That
6.
cannot be, my lord. That way, my then, my lord, my humble submission, my lord, let this case be disposed today, my lord.
We have heard you. This is the only consideration we have taken. If you want to argue more, we'll give you another chance by admitting it. If not, we'll dispose of, allow the writ appeal.
No, my lord, suppose, my lord, assuming, my lord, today also, my lord,
It's a 3-page judgment
my lord,
of the learned single judge.
my lord,
The only issue was they have quoted section 6
My
of
lord.
CCS rules,
My lord.
which is non-existent.
my lord,
Now we find that it is a wrong quotation of the provisions.
my lord.
It is rule 3.
My
It's a
lord,
misconduct.
no, my,
You have encroached
no, my lord,
on department land.
my humble understanding that this will not come under
That issue will take it and will allow the writ appeal.
no, my lord, my humble understanding that my lord under rule 3, this my, even assuming, my lord, they are saying rule 3, my lord.
Mr. Estafet, learned counsel for the petition. We're giving you a chance. We'll admit this and we'll argue.
My lord, I believe this always.
If you want to argue that much, we're allowing the appeal.
No, my
We'll
lord,
dispose of the writ appeal.
no, I'll argue
We're
my.
convinced as of now.
My lord. Instead of my lord keep pending, my lord, kindly appreciate
See,
this.
problem is no other issues has been discussed by the learned single judge.
But the issue on the main issue, my lord, that it is not the case, my lord. Learned judge did not-
Learned single judge has said you have punished a man which is non-existence.
my lord.
A provision which is non-existence by quoting section 6. We agree that he was correct.
Well.
But other issues, it was only of wrong quotation of the provisions of the rule.
Well, other issue will not go in their pair, my lord. Other issue, my lord. This read petition, my lord, was filed by me, my lord. That non-consideration of other issue, my lord, goes against me, my lord, not there in their pair, my lord. Therefore, my humble submission, my lord will kindly make endeavor to dispose this today, my lord.
Not endeavor, we have heard. What is your submission?
My submission, my lord, even except
We will dispose it.
My lord.
It's okay.
even
Lordship, otherwise may I propose subject to my, I'm serving copy to Lordship, my friend. Then it may be taken up tomorrow for disposal, Lord. I think it will be clear to him also.
He doesn't want your additional effort.
no, my lord. I believe, my lord, all the issue in the appeal memo, my lord.
Tomorrow, Lordship, otherwise, Lordship, if my friend insists to have.
Tomorrow, my lord, okay, my lord.
Huh?
Tomorrow, my lord, if my lord allow, my lord. Give it.
Why tomorrow?
My lord, can I, my lord, this, my lord, he is pending against me 2 times, repeatedly, my lord, time and again, my lord. Even high, this honorable court, my lord, passed 2 order in this case, my lord. They are, due to this, my lord, my promotion, my lord, is being denied, my lord, since 2017, my lord.
Mr. Estafet, learned counsel for the learned senior government advocate for the state appellant list of also heard and Mr. L. Permel, learned counsel for the respondents. After hearing the learned counsel for the parties at length, we find that the matter requires detailed examination of the matter. List of admit this appeal list for hearing after 2 weeks. In the meantime, the learned senior government advocate may furnish the copy of the additional affidavit to the learned counsel for the respondent. We're fixing it for hearing, admitting it, because if we dispose it today, a writ appeal will be allowed.
My lord, if I do my humbly believe, my lord,
Thank
if
you.
I have to argue, my lord, there is no chance, my lord, this case it will be allowed. Obviously.
If tomorrow, if,
After 2 weeks.
okay.
Yes, madam.
And I'm appearing on behalf of Mr. S.K. Deori.
Huh?
I'm appearing on behalf of Mr. S.K. Deori, Your Honor, in this case.
SC?
This matter, S.K. Deori.
SK Dairy.
This
Huh,
matter may
what do
be
you want?
adjourned for today, Your Honor.
Hmm?
The matter may be adjourned for today. On the consent of both the parties, Mr. P.K. Tiwari is also not present here.
Have you checked up? Can we take up this matter? Is it related to those NSPC matters?
Yes, related to this compensation matter.
No, of the lower subvention
Yes,
project. Can I?
Yes, I really.
Have you not gone through? Okay, we will list it. In the meantime, you examine whether
Yes.
this court can take up this matter on. Because in some related matter, I have appeared as a government council. Lower Subansiri project. May not be this case, but they are related to this case. You examine it, you find it out.
Yes.
All right.
Yes.
On the prayer of MS Srencho, Learned Council, for the Learned Council appearing on behalf of Mr. SK, the Learned Council for the petitioner, appellant. Submits that matter may be adjourned for 3 weeks.
3 weeks.
Huh?
3 weeks. Your Honor.
3 weeks, huh? List of praise for adjournment of the matter for 3 weeks. List of praise allowed. List this matter after 3 weeks.
Yes, Your Honor.
I don't know where.
So no affidavit, why?
My lord, the last time also I raised the preliminary objection.
Yes.
My lord, there is a deliberate violation of High Court Rules 2011, my lord.
Anyway,
Yes.
you bring on record on the objection in the affidavit. You are
Exactly,
supposed to
Doctor.
file an affidavit.
Yes, yes, madam, we got the parawas comments, but it's under typing. my
That
lord.
was your submission last occasion.
And then subsequently, I wrote to the department seeking some clarification. They are yet to give the
What
clarification.
is your preliminary objection?
Preliminary, my lord, if your lordship see, my High Court Rules 2011 pertaining to public interest litigation, it's still Rule 10, my lord. Chronological
No representation.
representation is given to the deputy commissioner. However, copy was served to the chief secretary. That is number one.
Hmm.
The number two, recitation, because para-wise they have to say how they get the information. Now-
Anyway, it's the allotment of the land to the institute.
Now,
Rather, you should be
most-
faithful to the petitioner.
Most important is, my lord, now public interest litigation is filed on behalf of round to the people who cannot approach. NIT, my lord, is such a big organization. Can there be a round to people, my lord, who
It's
cannot
okay, why
approach?
not on that? What he's saying is that this
And
300 acres of the
Yes,
land
yes.
was allotted. Now it is only 133
my lord,
acres.
there is not a single complaint against that, my lord, encroachment. That is the stand of the deputy
You
commissioner. We'll bring it
on
up,
paper.
no issue.
Heard Mr. G. Kato, Learned Council for the petitioner. Mr. Aris Nabar, Learned Additional Advocate General of the State. Press for is granted 3 weeks time to file affidavit in opposition. Aris, Mr. Arshika, Learned Council appears for respondent number 3 and 4.
Oh, oblige.
List after 3 weeks.
My lordship, we need some more time to file an affidavit, my lordship.
You are respondent number 9 and 10. Who is respondent number 9 and 10?
4 and 8 months.
Okay. Yes. What do you want?
Your lordship, the respondents are yet to file their affidavit in opposition.
Okay. Heard MS Sensor Learned Council for the MSK Wang Learned State Council pressed for and is granted 3 weeks time to file affidavit. It is seen that the the affidavit in opposition has already been filed on behalf. No. I had already filed the affidavit in opposition. List after 3 weeks. There is a you find out on next date, the recently Supreme Court has passed some orders regarding this stone crusher. All right.
Lordship, there is a 20 years of conviction. This IA, interlocutory application I have filed for suspension of conviction order.
Yes. On what ground?
Evidence is inconsistency in the evidence. There is a the I mean to say that there is
Records,
Lordship-
record is there.
Lordship, actually,
Trial court record is there. Trial court record is there.
LCR is there, Lordship, as per the course list, Lordship.
Okay. This is section,
section lordship POXO matter.
yes, in that case, we'll
Oh.
IA is so this maybe this was of tomorrow matter.
IA.
IA.
For what matter?
Regarding matter small matter matter. For
For what?
regarding there's a dispute regarding land. So it has to be resolved by
Is a writ
amicably.
petition.
Yeah.
Writ petition.
Yeah.
May it be your lordship.
Yes.
Back to mention item number 38 and 39. When this was regarding upgradation of post and the Public Service Commission examination on the last occasion, faced with some difficulty. One of the petitioner was arrested, my lord, as accused in the leakage, my lord.
30?
38 and 39.
Okay.
My lord, may grant me some time to seek instructions, my lord. I don't know
Yes.
whether charge sheeted or not.
Let us have some practice that if you can make a mention, submit a adjournment slip.
Right.
At least one night before, so that no one should be paid to go through the files.
That is,
There is a notification. If it
okay,
is
okay, my lord will take care.
advance adjournment
Yes,
slip.
we will do that.
Because
This we can only.
because this matter, I woke up at 5:30 this morning and I read that this.
This might have to be, my lord, these two may have to be separated in any case.
Okay. On the Mr. Deepak Landed Council for deputies, both, huh? 38 and 39. Petitioners submits that he may be granted 2 weeks, 3 weeks time.
Yes,
3 weeks time to obtain instruction stating certain developments in the matter. Mr. The in view of the above, no, accordingly, the writ petitions are adjourned for 3 weeks. This after 3 weeks.
and my lord, item number 14 may kindly be taken up day after tomorrow.
14.
Yes.
On the prayer of Mr. D. Pangi, Learned Counsel for the petition. List this matter on
Wednesday,
Notice
Wednesday,
3,
Wednesday, yes.
03/04/2020.
Oh, bless.
Lordship, may I please to mention item 17?
17.
Yes, I have to file affidavit in reply. Therefore, I may be given 4 weeks time, my lord.
17, 17.
17. I've taken concern of opposite party also.
Mr. D. Laji, on the prayer of Mr. D. Laji, Learned Counsel for the petitioner. List this matter after 2 weeks,
After 4 weeks, my lord.
after 4 weeks, so as to enable Mr. Laji, Learned Counsel to file affidavit in reply.
Affidavit in reply. Yes, most obliged.
My lord, I beg to mention item number 36, my lord.
36.
Yes, I'm on behalf of the counsel for the petitioner R. Sonan. This matter has been listed after a long time, my lord. So we are seeking for a fixed date, my lord.
37,
36, my lord.
36.
Yes.
We will take up today. We'll take it up today.
Counsel for the petitioner is not present, my lord.
Why?
He's busy in some this election, my lord.
He's contesting.
No, not contesting.
He's a candidate.
Yes. He got engaged somewhere, my lord, out of station.
I think it's over now.
Yes.
You cannot do anything now unless you are a contesting candidate.
Yes, kindly matter may be
It's
taken up.
2018 matter. What's
Yes.
there? It's a supply order was of 2017.
Yes, yes.
Nothing is there. You take instruction, we'll take it up day after tomorrow.
Day after tomorrow.
All right? Or after
Oh,
3 weeks.
After 3 weeks, my lord.
As a last chance.
Yes, yes.
Nothing. I don't think any live issue is surviving.
Yes.
Mr. What's your name?
B. Niarus.
So and so learned counsel appearing on behalf of Mr. Arsona submits that learned counsel Arsona leading in this matter is in discourse today, for which he seeks 3 weeks time. Praise the Lord. However, since the matter is of 2018, the matter is adjourned for adjourned as a last lunch. This after 3 weeks.
Deeply obliged.
My lord, I'd like to mention item number 8, 30 and 37.
8,
8, 30, 30 and 37. This matter may be listed after 3 weeks, yo.
8, 8.
8, 30 and 30.
8 is with 5, 6, 7, 8 together.
My senior have instructed me to just only my senior has instructed
It
me
is
to
listed along with item 5, 6, 7.
8, 30 and 37 years.
Hmm?
8, 30, 30 and 37.
Sir, this item 8 is listed along with item 5, 6, and 7. What is to be done? Have you taken a consent from other side or the other the counsel for the petitioner?
No, my senior have instructed me. Just
Your Honor, I'm appearing on behalf of
Item 5, 6, 7A.
Yes, Your Honor.
You are also seeking adjournment.
Yes, Your Honor.
On the prayer of learned counsel for the parties, list this matter, item 5, 6, 7, 8, after 3 weeks. Yes. And
Lordship 37.
37.
Yes. After 3 weeks, yo.
37 on the prayer of Mr. Sensor, learned counsel for the parties, list this matter after 3 weeks.
And yours is 38 also.
38.
Yes.
Already adjourned, 38.
Okay, madam. Pleasure.
Yes,
Lordship, I beg to mention item number 4.
yes.
Lordship, I'm on behalf of G Talo. The matter may be adjourned after 3 weeks.
Item 4,
Yes, Your Lordship.
G Talo is for respondent.
Yes.
Okay. On the on the prayer made on behalf of Mr. G Talo, learned counsel for the petitioner. Respondent, this matter after 3 weeks.
Your Honor, I'd like to mention
Like-
item number 3, 3 and 2, Your Honor.
3,
Yes, Your Honor. We have not received the paragraphs comment from the department, Your Honor. So
3 is for, we'll see.
and Your Honor,
Any objection?
this
Any
thing-
objection?
No,
Item 3.
I mentioning 3 and 12.
No, 3 and 22, Your Honor.
No, you first one by one.
Ah.
3 you are mentioning on behalf of?
Standing Council Tabatagum.
Okay. Tabatagum. On the prayer made on behalf of Mr. T. Tagum, London Standing Council Education Department.
And Your Honor, his name may be
Consent of the Learned Council by the petitioner. List this matter after 3 weeks.
3 weeks. And Your Honor, Tabatagum's name may be listed in the court list, Your Honor.
The name of Mr. Swenso, Tabatagum London Standing Council may be reflected in
And
the
you're
cause list. Then item 12,
I think no, 22.
22.
Yes, Your Honor.
Affidavit has not been filed.
We'll see.
Well, should have come for orders actually, coming up for the second time.
Okay. So we will grant time in that case. Same on the prayer made on behalf of Mr. T. Tagum, Standing Council for Education Department. And on the consent of Learned Council for the petitioner, Mr. Deepak. This matter after 3 weeks, so as to enable. The next one. The Learned Council, the Standing Council may file affidavit in opposition in the meantime.
And Your Honor, item number 33, Your Honor.
36,
No, 33.
33.
Yes, Your Honor.
We'll see. This is order. Order, you be there. We'll see.
Legend. And Your Honor, item number 35.
35.
I've sought consent from the other parties also.
Why? This 2015 matter, nothing.
Yes, Your Honor.
Where is Mr. The London Council for the petitioner? At least we will take up one hearing matter today. 2015. Where is the London Council for the petitioner? It's more.
His junior was there this morning, Your Honor. I
Huh?
informed him. I informed her. His juniors.
You be there, you inform him. It's 2015 matter will take up.
Legend.
Item 35. Are you ready?
Yes.
You are ready? Okay. We'll take
But
it.
Your
up.
Honor, the standing council for the health department is not in the session. Your Honor.
Where he is?
It's not in the session, Your Honor.
Huh?
It's not in the session.
Where he has gone?
I have no knowledge of that, Your Honor.
You don't know where your senior has gone.
Yes, Your Honor.
Huh?
He's just instructed me to take adjournment.
Do you have the brief? Do you have the brief?
No, I don't have the brief, Your Honor.
Do you have the file?
Pardon?
You take the file, we'll list after day after tomorrow. All right.
Obliged, Your Honor.
On the prayer of Mr. So and so. Your name, please.
H. Tai.
Appearing on behalf of Mr. T. Tagum, London Standing Council of Health Department. List this matter on 04/04/2024. 04/04. 04/04. Are you fixing the matter or what? We'll take it up on the 4th.
Obliged, Your Honor.
But you find out whether such type of matter, can you approach the consumer court? That issue, you may allow you to approach the consumer. So you explore, find out whether it is possible or not, right?
Obliged,
Fourth,
Your Honor.
huh?
Yes, madam. I'd like to mention item number 29, madam.
29.
Yes, madam.
Matter is supposed to be listed in admission column, my lord.
We'll see what is there. It's order listed. We'll see.
My lord, leading counsel is out from the other.
No, what order has to be first? We'll see. Where is Mr. Kato?
Kato is there.
My lord, our affidavit is ready for
Okay,
filing, my lord.
maybe because of that only.
My lord,
On the
For-
prayer
just
of
for
learned
filing.
counsel for the parties, list this matter after 2 weeks.
my lord.
And my lord, there is an interim order that may be continuing.
In the meantime, Mr. M. Kato, learned DSJ may file
My lord.
affidavit in office.
My lord.
Interim order passed earlier shall continue.
Development.
May I, my lord? I beg to mention item number 24, my lord.
24.
Yes. My lord, this matter will be taken up to 2 weeks. I have taken the consent of petitioners.
Yes,
This matter may be taken up to 2 weeks, after 2
after
weeks.
2 weeks.
Yes, I have
On the
taken the
prayer of
consent.
Mr. T. Tagore, learned counsel for the respondent,
Yes.
list this matter after 3 weeks.
Much obliged.
Mr. J. Jini, learned counsel for the petition present.
May I please? Your Honor?
Yes.
When I beg to mention CRP 10 of 2024,
Hmm.
only for passing orders with regard to steps of notice on respondents.
Where it is?
For listing today on,
No, CRP before court number 2.
pardon me,
Court number 2. Revision petition
revision petition,
before court number 2. You may mention there.
obliged.
Lordship, I beg to mention item number 13, Lordship.
13.
Lordship, I am for the petitioner. This matter is fixed for admission hearing, Lordship. Pleadings are completed.
Hmm.
Today, I don't find DK Deori in the court, Lordship. In fact, I have called him also.
On the prayer of Mr. J. Jini, learned counsel for the president, list this matter after 4 weeks
2 weeks, Lordship.
for admission hearing. Mr. M.S. Sangeeta, P. Sangeeta, learned state council president.
Much up. May it please, Your Honor.
Yes,
Your Honor, I beg to mention item number 18.
18,
Lordship, kindly, this matter may be fixed on 22 of this month.
22.
Yes, Lordship.
Why, auspicious occasion?
As instructed by my senior Lordship.
What is this?
My lord, forging the documents, my lord,
Perjury.
the false statement has been made in the affidavit, my
Your
lord.
colleagues, what's there?
My lord, difficulty is,
Are you sure? I mean, you cannot see eye to eye. Is your colleague?
however, my lord, false declaring the false affidavit and the filing false affidavit before this honorable court in a writ proceedings, my lord, that amounting to, my lord, the serious mistakes on the part of the, my lord, the respondent, private respondent hearing. So we are only bringing the notice of this honorable court regarding, my lord, the false filing of the false affidavit.
No, that's
By which, my lord,
he's your colleague.
serious mislead has been, my lord, made, my lord. So
It's-
there must be certain, my lord, the
It's your
procedure.
colleague out of transparent posting
My
of
lord, exactly. And now he is enjoying, my lord. Only this criminal petition, out of that, my lord, the false affidavit, we are only, my lord, proceeding.
you discuss with your client petitioner. Well, your colleague only.
My lord, in that case, my lord, matter may be fixed on 22. In the meantime, we'll take instruction. my lord.
On the prayer of Mr. D. Lona,
Yes, Lordship.
learned counsel appearing on behalf of Mr. Deepangi, learned counsel for the respondent. And not being objected to by learned counsel, Mr. M. Kato, learned counsel petition. List this matter on
22, Lordship.
22/04/20.
In the meantime, my lord, will come with the instruction. Development.
Obliged, Lordship.
May I please, Your Lordship?
Yes,
Lordship, I beg to pray for adjournment of the matter, item number 26, Your Lordship.
26.
Yes, Lord. The conducting counsel, Miss G.A.T., the additional.
We'll see. It's in order stage. We'll see what's to be done. All right,
Obliged.
you be there.
Item number 1.
My lord, this morning, he personally telephoned me as he is still out of the station. My lord, apprise your lordships to, my lord, the pass over the matter for a day, my lord.
Today,
My lord.
when you want,
Matter maybe pass over for a day.
when
my
do you
lord.
want?
Tomorrow, my lord. He's on the way, my lord. The extended counsel, Mr. G. Tarak, is on the way, my lord.
But then I'm afraid such type of relief can be granted or not.
Yes, my lord. Personally, I
I
mean,
will be assuming
My lord, I
the
personally,
power of the executive, which is not permissible.
my lord, personally, I requested him to, my lord, at least allow me to, my lord, submit my tender documents, my lord. He is saying that, my lord, if
No,
the,
in that case, though, why you should approach this court? You talk to him. If he allows you, who will be stopping you?
my lord, difficulty he has expressed is that the time limits has already been barred and has already been passed on 23rd,
See, unless you can show that because of the MCC,
my lord.
onset of the MCC, it could not be allowed and you should be given a chance, or you are saying that the time for submission of tender was
Correct.
too short, and I mean it should have been a reasonable time and all those. That is, if it is not there,
My lord, fairly,
this
there
court
is,
is really upright.
to make, my lord, fair submission, my lord, there is no bar, my lord. However, my lord, the officers engaged in such office, where
Because
from,
you know, certain issues, certain things, even the consent of the parties, we cannot pass,
my lord.
being a constitutional court. That we
Yes.
have to, you kindly look into it. We'll take it up definitely tomorrow.
Tomorrow, my lord.
But then I have thought about this. This court has thought about this. Because it should not be there should not be any wrong signal.
It's true,
I
my
mean,
lord.
the wrong message should not go.
My lord, true, my lord.
Because
Prejudice is,
every petition can be allowed, accepted by the High Court.
my lord, what we are trying to negotiate with the department is,
No, if you negotiate with
my lord,
it's up
if
to you.
once
But
we,
then even if there is a consent
yes, my lord,
of the parties
my lord.
by the learned councils, we
My lord,
we may be reluctant.
my lord, once we are allowed to, my lord, submit the tender documents, my lord, otherwise, my lord, this will be, my lord, withdrawn. of
But
course,
in
my lord.
any case, we may not be given a direction.
True, my lord. Only for
All
the
right.
extension of the, my lord, the
We'll
only
see.
last date of submission of tender, my lord.
On the
It is the
prayer of
only period.
Mr. M. Kato, learned counsel for the petition, this method. Tomorrow, day after,
Tomorrow, my lord.
tomorrow, on
Or in that case, my lord,
02,
day after tomorrow, my lord. It is
03,
coming tomorrow, my lord.
0304 2024.
Third, on third. Deeply appreciate.
My lordship.
Yes.
Lordship, that petitioner was appointed in 2002 as a
Yes.
casual driver in PSC department under lordship.
Hmm.
Phase number 19 is appointment under lordship.
Hmm.
And phase number 20 is type copy lordship.
Type copy is what?
Lordship, this is appointment of petitioner as casual driver in PSC department lordship.
89 days. 2001, 89 days.
Now, lordship, that
2001.
yes, lordship. And
Yes.
now, lordship, respondent number 3 has appointed one junior, promoted to one junior.
Ah.
Phase number 29, lordship. This is inferior order, lordship, that we have made. And this is appointment of the lordship private respondent, phase number 29, lordship.
Hmm.
And whereas this private respondent is appointed on 2005, lordship. 3 years junior to petitioner, lordship. And petitioner has lordship serving as casual driver for the 22 years in the department, lordship.
But then you were appointed on only for 89 days.
No, lordship, but then it is still prevailing. And I have not been terminated.
Where
still
it is?
also.
Show us any documents where you have been allowed.
Lordship, and next phase,
Last allowing you to the continue last order. It's in 2006.
yes, lordship. And again,
This is an
2006.
engagement
Exactly,
letter.
lordship.
Then
Then, lordship, this is also in 2006 that I have been directed to proceed Itanagar as a driver, which means I have not been terminated and still in the condition of this lordship, casual driver, lordship.
the page 28.
No, page number
Consider
24
the
is
list of casual driver under Allo division. Private respondent is respondent number 2. Where is your name?
lordship, page number
Page 28. Where is your name?
Yes, Lordship, exactly. This is also one list, impugn list that Lordship, my name has not been mentioned, in fact. However, still I am the department driver, Lordship. And phase number, Lordship, 24 is one order. Phase number 24, Lordship.
Yes, I've seen it, 2006.
Exactly, Lordship. That when I was appointed in 2002 and till 2006, there is order. And still that I am payment salary, Lordship, from the department, Lordship, which is I have not been terminated, Lordship. And Lordship, for the promotion of the department, this is basic principle is seniority.
But
Lordship.
Mr. G. Kato, learned counsel for the petitioner. Next para. Anything you want to say?
Lordship, the petitioner has been appointed against sanction scheme, Your Lordship. He's appointed under a
Then
scheme.
you have
Your
an
Lordship.
elected factory manager.
And that is why maybe, Your Lordship, his name is not in the seniority list also, Your Lordship. Page 20, Your Lordship, he is appointed under against sanction scheme of Alo subdivision, Your
But
Lordship.
then you have allowed him to continue. Facts remain that.
But under a particular scheme, Your Lordship, he has been working, Your Lordship.
We'll see, you file your
Lordship.
response. What is it? Heard so and so, learned counsel for the petitioner. Next para. Challenge made in the state petition. Is the impugn order dated 0802/2022. It's after 20. It's 22.
Lordship. Sorry, Lordship.
Appointed in the year 2022.
Yes, Lordship.
0802/2022.
Lordship, I was
Passed
appointed.
by the, issued by the superintending engineer, PHE and WS circle within bracket Bennett. Comma, whatever. The respondent number,
124,
no. Respondent number, private respondent,
private 5.
Private 5, Lordship.
respondent number 5 has been appointed as WC driver on officiating basis on the ground that the petitioner is senior to the respondent number 5. The petitioner who was appointed as casual driver in the year 2001, much senior to the respondent number 5. Issue notice returnable by 4 weeks. MS Arbasar London State Council accepts notice on behalf of respondent 1, 2, 3, and 4. No formal notice need be served. However, extra copies be furnished to the London Council. State response. Petitioners to take steps for service of notice of respondent number 5. Register was within 2 days. This after 4 weeks.
Right, Lordship.
No interim. 2022.
Item number 9.
Yes.
Relating to education only.
Item number 9, standing council is out of station, so for education,
Any affidavit? Any affidavit?
Of course, Lordship, on our respondent number 4, we have filed. Respondent number have filed. Of course,
Respondent number 4 is who?
Deputy Commissioner.
Huh? Who is respondent number 4?
Deputy Commissioner, Lordship.
Ah,
Additional Deputy Commissioner.
what is your stand?
No, from our side, whatever that we only we can only forward recommend only. We are not the issue authority.
So who will decide this? Government will decide this.
No, Lordship, education department.
Government education department is part of the government.
Still, Lordship, they have their.
They have to initiate, but ultimately government
they
has to
they
decide.
their
Chief Secretary,
council.
respondent number 1. None appears on for petition on call. Mr. So and so learned counsel for the petition, petitioner appearing on behalf of Mr. T. Tagum. Learned counsel. T. Tagum. T. Taba. T. Tagum, learned standing counsel to education department is granted 2 weeks time to file affidavit in opposition. Mr. I. Ram, learned physician senior government advocate, has submitted that affidavit on behalf of respondent number 4 has already been filed. Just however, the not however, huh? Mr. I. Ram, learned addition senior government may file an affidavit on behalf of the respondent number 1 also. Please. Government has to finally decide. List of 4 weeks.
Number 10.
May I please, your Lordship?
Yes.
Lordship, this is, in fact, this matter is covered by one of the judgment of this very court, Lordship. Similar situated matter, Lordship. Similar situated matter, Lordship. Here we have challenged the judgment and order passed by the arbitration board, which is in violation of Regulation 30 of AFR, Lordship. This whole proceedings was carried out before the amendment was brought in, Lordship. Same issue, Lordship, same stretch of roads and same dispute, same area, but lane is different, Lordship.
What happened to this matter?
Lordship, or disposed of, Lordship. This is the final order, Lordship.
No, before the
The impugned order was set aside and quashed, Lordship.
yes.
Liberty was granted to both the parties to approach the appropriate.
That's why what happened thereafter?
Lordship, I didn't take instruction,
You
Lordship.
take instruction, why unnecessary pass in same orders like this? Parties are different.
Parties are different, same stretch of road, lane is
Same
different,
lane
but
is
the
different.
issue is same, Lordship. That's what I'm trying
You
to
find out
convince, Lordship.
what had happened to those cases after this judgment, order.
All right. I'll take instruction.
Hmm?
I'll take instruction.
Is not it?
Sir.
By now, they might have settled this of 2021 matter.
Exactly.
All right.
All right.
And this was disposed of on
2022, Lordship.
22. I
February.
think by now, things might have been settled now. It's a construction of road,
Construction of road.
right?
Yes, Lordship.
4 lane, 2 lane.
Two lane.
lane.
Two lane.
I think this might have been settled by now.
Lordship, I'll take instruction.
On the we had Mr. J.G. Learned Counsel for the petition. And also had Mr. I read up London additional senior government advocate. What is your instruction?
No,
Any affidavit?
Lordship,
Have you filed any affidavit?
yeah, we have filed, Lordship.
What you were saying?
No, we are saying the method, since there was dispute, we wanted just to settle the matter amicably only, Lordship.
You also take instruction what had happened to these cases, since you have filed an affidavit.
Lordship.
Because similar method this court has allowed, and unless parties they agreed for arbitration, you cannot force them to go for arbitration, right?
Yes.
So you are trying to defend your action, so you also take instruction, both of you. Learned counsel for the parties are directed to obtain instruction. As the similar matter in a similar area, the similar matter involved in the same area has been disposed of this court on in the year 2022. This matter after 4 weeks.
3 weeks, Lordship.
3 weeks.
3 weeks. Much.
May I please, madam?
Yes.
Here I am challenging the malord impugn order passed by the malord Indian Oil Corporation on malord 24/3/2021,
Yes.
suspending the supply of malord petroleum products to the malord MS malord Kamdak Automobiles malord without any prior so cause notice malord. Malord, which has been put to challenge before this honorable court, malord. Malord, before coming to that impugn order, malord.
Yes.
Malord, in the year 1985,
Yes.
the then Assam Oil Division has approved and authorized RO dealership, malord, in the name of Rijir Kamdak by issuing LOI on 14/10/1985, malord. Rijir Kamdak is, malord, the cousin brother of my lord Mento Kamdak. Mento Kamdak is the petitioner's father, my lord. My lord, because my lord, the Rijit Kamdak does not have the financial, my lord, soundness, and also my lord, like non-availability of the land, he approached my lord Mento Kamdak, petitioner's father, for a partnership deed, my lord. Because my lord Mento Kamdak was having.
Basically, you want a reconstitution of the.
Yes, yes, my lord.
Right.
And my lord.
What is the provision of reconstitution?
My
And
lord,
then the widow of the wife of the late so and so, Rijir Kamdak has filed a complaint.
Complaint before the.
That's the reason they are not having they are not
Considering
reconstituting.
that.
We'll see,
My,
that's the
my
only issue.
fact is that, my lord, the partnership deed has been entered between the my lord Rijir Kamdak and Mento Kamdak, which is a my lord partnership at will, my lord. Partnership as will is defined under Section 7 of the Partnership Act. It says, my lord, partnership at will means there is no provision is made by the contracts between the partners for duration of the partnership period or for the determination of partnership, my lord. So, my lord, by virtue of that, my lord, it's a, my lord, partnership at will, my lord, and subsequently, my lord, in the year 2000, my lord, and it has been, my lord, approved by the IOC in 2001, my lord. So the MS Kamdak Automobile is operating in the name of, my lord, in the status of, my lord, a partnership firm, my lord.
Basically, you have the person who have been given.
Yes.
Rijir Kamdak.
Rijir Kamdak.
He has relinquished the partnership.
Yes, because, my lord, because of, my lord, he has entered into government service.
That has been accepted by.
That has been accepted by, my lord, the, my lord, authority also there. It is in their knowledge, my lord. After that, my lord, Mento Kamdak has filed an my lord reconciliation, my lord reconstitution application before the authority, my lord, in the year 2001, my lord, saying that giving all the details, my lord, of relinquishing the partnership by Rijir Kamdak, my lord, and other affidavits sworn by the my lord wife of the my lord Rijir Kamdak, this is Bhumi Kamdak, my lord, saying that she doesn't have any interest in that partnership firm, my lord. It was reconstitution application was filed in the year 2001 itself, my lord. And in their affidavit, they are saying that, my lord, both the my lord, it is, my lord, is the case that once it is relinquished, my lord, it's a sole proprietorship of the, my lord, Mento Kamdak, my lord. Petitioners first.
Any suit is pending?
No, my lord.
Okay.
So, my lord,
So you would like to file a rejoinder affidavit or not?
my lord,
Rejoinder affidavit.
no, my lord. This can be, my lord, disposed of, my lord. Only ground, my lord, made in the, my lord, affidavit is that, my lord, I have not produced the, my lord, legal error certificate of the, my lord, Rijir Kamdak, my lord.
Hmm.
My lord, in
It is-
this case, may I interrupt, my lord, in the meantime, my lord?
Just
In a short.
wait. Just wait.
Because, my lord, it was a, my lord, partnership at will, my lord. Once he has relinquished, my lord, he doesn't have any interest in that, my lord, partnership firm, my lord. Neither his, my lord, successors, my lord. So, my lord, now they are in the affidavit, they are saying that, my lord, you have not produced the, my lord, legal hair certificate of that Rijir Kamdak, my lord. Both Rijir Kamdak and Mento Kamdak died in the year 2014, and one is Mento Kamdak died in 2017, my lord. Now, I have also annexed in the reconstitution application subsequently filed by Toli Kamdak, the petitioner, my lord.
After the death of your father.
Yes, my lord, along with all the requisite documents.
Okay,
my
I will just share them.
my lord.
What
My
is the
lord,
problem?
Problem is, my lord, we are the, my lord, marketing company, Indian Oil Corporation. We want to continue the, my lord, dealership.
Yes.
My lord, we have to follow the guidelines
Yes.
properly, my lord. There are reconstitution guidelines.
Yes.
So for my lord, relinquishment of the, my lord, Rijir Kamdak is conduct, that is not as per the procedure. He only, my lord, submitted an affidavit relinquishing his, my lord, share. That cannot be accepted. That has not been accepted. My lord, that is why the partnership, my lord, firm has been continuing. While, my lord, the reconstitution application filed by the present petition, then, my lord, all these irregularities came to the knowledge of the Indian Oil Corporation. My lord. As per the procedure, my lord, clause 4 and 5, my lord, no objection certificate from all the legal heirs of the, my lord, partners is required, first of all. Secondly, my lord, there is a provision for meeting of the, my lord, legal heirs of the, my lord, dealers, along with the committee of the, my lord, IOCL, constituted as per the guidelines, where, my lord, the legal heirs of the petitioner did not appear. That is why, my lord, we could not, my lord, continue with the dealership. My lord, impugned order has been passed. My lord, in fact, my lord, it is under, my lord, stay. Stay is operating, and as pursuant to the interim order, they are running the market. My lord, in the same circumstances, same factual circumstances, and there is a provision for appeal also, my lord. In, my lord, clause 29, there is a provision for appeal. That is why, my lord, in the same circumstances, my lord, there are some orders. One of such orders may have placed, my lord, to prefer a fresh representation before the, my lord, executive director of the Indian Oil Corporation, who look into the all this aspect and pass a speaking order until, my lord, finalization of the representation, that interim order. That was the order passed. Now, not only this.
Are you allowing him to run the?
If, my lord,
are you allowing?
Now, my lord, in pursuant to the interim order, they are running. There is an interim order in this.
You filed rejoinder. And have you relied on those? They are
Well, I have
relied
to-
on the guidelines.
My lord,
Because
they
what
are
we have
silent.
seen, what I have seen, what this court have seen is we'll have to go by the
Excuse me.
guidelines only.
Yes.
My lord,
Their
in the
guidelines.
same circumstances, similar circumstances, I have, my lord, shown the order.
In fact, this court has dealt with in principle set
My lord,
one matter.
this order is squarely covered, my lord.
My lord, just for a moment, my lord.
Yes.
May go through the order, my lord.
Because at the end of the day, you will have to, ultimately, you have to fulfill the guidelines
Guidelines.
for reconstitution.
Yes.
That is why
Of course,
instead
my
of, my
lord.
lord,
Of
You
course.
may have a difficulty. Suppose there is a requirement of making, they have I mean, what do you call it?
my lord,
From the legal
reconstitution guidelines.
Huh?
Reconstitution.
Reconstitution, you need to have the permission of the legal heir.
Yes, my lord.
The difficulty would be once the man died in 2000.
My lord. My lord, in fact,
One, and you have
both the
allowed them to
partners has
continue.
now, my lord, expired.
Huh?
Both are expired, my lord, Rijir and my lord,
Yes.
his brother.
No, that the other one.
There are
other
some
partner
other
expired long
irregularities
time.
also, my lord, that my lord, in the affidavit.
Yes.
My lord, the father and mother, although my lord,
Sir,
they-
you file and rejoinder. We'll see.
instead of my lord filing of rejoinder, my
We'll
lord,
continue. We'll allow to
if my
continue.
learned pen agree, my lord, lordship may dispose it of by this order, my lord.
No.
Almost,
I
my lord,
I
lords-
don't think allowing them to file again press representation will not serve their purpose.
lordship may kindly see that there is a provision for appeal also, my lord. Grievance redressal, my lord, as per guidelines, my lord.
It's your guidelines only.
Because, my lord,
We agree that it should be as per the
My
guidelines,
lord.
but appeal may not be that necessary.
My
Because
lord,
you
there
have
is-
already passed an order.
My lord.
Rejecting
My lord, this
his-
is not
rejecting
a
his
final,
claim.
this is not a final order.
No,
This is only
no,
suspending
my
the order, my lord.
Till date, my lord,
Suspending the
they had not
order.
passed a final order rejecting my reconstitution application.
That has not been passed, my lord.
So
this is
question
an,
of filing appeal does not arise, my lord.
We have not.
By the impugn order, my lord, the supply of the petroleum product has been stopped, my lord.
What do you say? Will direct you, will satisfy this order and will direct you to file a fresh petition for reconsideration.
It is only pending before the, my lord, the authorities, my lord, my application.
What he is suggesting is that to file a press representation. But then there will be a
That
impediment
representation
because,
has been
because
prepared.
they want that you should obtain the NOC from the legal heir of the
legal
partners.
My
That is
lord,
the
my submission is that, my lord, once it is a, my lord, partnership at will, my lord,
yes.
and he has relinquished the partnership, my lord, in the year 2001.
There's the
itself.
question of
Yes,
taking
question of
objection.
obtaining legal heir certificate, my lord.
Okay.
This is the main issue, my lord, before this honorable court, my lord.
No, legal heir certificate though you cannot obtain
Yes, my lord.
from this late rigid.
Yes, of course, my lord. Because
But then what they are saying is, as per the guideline, what it is?
My lord,
NOC from what legal year?
My lord.
What is the requirement?
Clause 4 at page, my lord, 11. Clause 4 and 5, my lord. Relevant person at page 12 of the guidelines.
Yes.
Clause 4 and 5, my lord. On what I copy আছে মোটা তো নাই এগুলা সব অনলাইনে চলে না Only first line of the clause 4 and clause 5 is relevant, my lord. But others, my lord, new, my lord, for the new, my lord, comers to the dealership.
no, I have not gone through that provision, my lord. To my understanding, my lord, if it's a, my lord, existing partnership, my lord, partnership firm, my lord, a subsistence of the partnership firm, if one partner dies, my lord, then, my lord, question of obtaining legal heir certificate from the other partners is required, my lord. Here, my lord, in my case, my lord, there is no question of, my lord, requiring, my lord, legal heir certificate from the Rijir Kamdang, my lord. Yes, because he has already relinquished his partnership, my lord.
Mr. Sarma, what do you say? Suppose one partner dies.
My lord.
What is the requirement of that?
My lord, if my lord one partner dies, my lord, then my lord,
It's,
clause 4 and 5 apply, my lord. In fact, if the both partners died, my lord, in this case also,
Have you answered what he has submitted?
yes, my lord, lordship. may
According to him,
My lord,
the late Rizir Kamdak was the initial, one of the partner.
my lord,
He has relinquished long time back, which you have accepted,
no. No, my lord,
right?
because my lord, if, my lord,
If a-
whatever may
if
be,
a-
if he
if a
expired,
partner,
he-
if a partner relinquished
my
and
lord,
died,
my lord,
it is in case of death.
my lord,
According to him, he has
he
died.
had to apply for.
Now, reconstitution is in
My-
respect of the late Bento Kamdak.
My lord,
And the petitioner is the legal heir.
that answer is my,
The legal heir of this Rizir Kamdak, they cannot I mean, no, they cannot be made a partner or reconstituted as a member.
my lord, in case of my lord, relinquishment by following the proper guidelines, my lord.
Yes.
Only by way of an affidavit, my lord, he relinquishes share. That cannot be, my lord, that has not been
So
approved.
you have been
That,
allowed.
that has not been approved, my lord. Lordship, may I
It
have,
was of 2001,
my lord,
25 years back,
my lord, lordship, may
24 years back.
kindly peruse the paragraph 6 of my affidavit in opposition.
Paragraph 6.
Paragraph 6 at page 4. That which triggers the statement and affirmation made in paragraph 4 of the writ petition. The answering deponent, while denying the same, begs to state that partnership firm has not been dissolved and converted to a proprietorship firm as per the records maintained, that Rizir Kamdap cannot relinquish his share and claim in the retail outlet by way of an affidavit, as there is a reconstitution of policy in place to cover such scenarios. Further, the employees of late Rizir Kamlab in the government of Arunachal Pradesh has a violation of the terms of the dealership agreement, and as such, the retail outlet is bound to face the contractual consequences of such action. In paragraph 7, my lord, we have stated, the answering deponent begs to state that from the record, it is reveals that proposal for reconstituting the retail outlet was attempted in the year 2001, but not concluded.
Next line, my
Then
lord.
your lordship may kindly,
Partners of the firm have died, and Mento Kamdak died in 2017 and Rizir Kamdak died in 2014, my lord. Now, my lord, from 2001 to, my lord, 2017, my lord, they have not considered the reconstitution application filed by Mento Kamdak in the year 2001, my lord.
and paragraph 8, your
And
lord,
paragraph, I'll just clarify, my lord, paragraph 6, my lord, is contrary to the, my lord, law as stipulated in under section 7 of the Partnership Act, my lord. Only requirement is that, my lord, why they have not considered, my lord, reconstitution is paragraph 10, my lord. May I read, my lord? Paragraph 10, my lord. That with regards to statement made in paragraph 8 of the writ petition, the answering department, while denying the same, begs to state that although the petitioner has submitted proposal for reconstitution of retail outlet dealership in favor of him as a proprietor, but no objection certificate from all legal heir of the both the partners has been submitted, which is required as per reconstitution policy, madam. My lord, Mento Kamlaks, my lord, all the, my lord, NOCs has been submitted by the sons and daughters, my lord. But, my lord, question of submitting, my lord, no objection certificate from the legal heirs of the, my lord, rigid conduct does not arise, my lord. As because it was a, my lord, partnership at will agreement deed, my lord, and he has relinquished the same in the year 2000 itself, my lord, because of he being absorbed as a government employee, my lord. And to that effect, my lord, the application has been submitted by Mento Kamlak. Lordship will find at kindly see page 50 of the, my lord, read petition for a moment, my lord.
You file a reply. We'll consider it after a week.
My lord,
All right.
May I request my friend to, my lord, provide a copy of the, my lord,
Guideline.
guideline, my lord.
guideline is in
Guidelines is the best.
website, my lord. It is
You-
in the
you have-
website. I have.
You have annexed.
No,
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 he has not
it is in the website, my
Guideline
lord.
is
My
the
learned
basis.
pen will get.
My
The
lord, and
reconstitution will be
nothing has been, my lord, he has not annexed the guidelines also,
My
my lord.
lord, it is in the
It is
website. I have downloaded this from the website only, my
The
lord.
reconstitution, the guideline is the basis. But the reconstitution is.
Reconstitution
because
guidelines
it's
is
a company.
in the IOCL website, my lord. Everything is in the website.
So we'll take it after 1 week.
My lord, only, my lord, problem is, my lord, the petitioner
Mr.
is, my lord, continuing the dealership
You
without any authority,
You allow him to continue.
Without any
till,
authority.
till final disposal.
or
That's why I'm.
if my lord,
That's why I'm saying, we'll take it up next week.
my lord, or
Tuesday-
if your, if
My
my,
lord,
if
next
my,
Tuesday, Wednesday,
At least 3 weeks, my lord.
3 weeks.
or if my learned friend agreed in the order, finally, my lord, the petitioner will get the order which, my lord, I have produced before your lordship. If, my lord, I have furnished a copy, if, my lord, he has gone through it, that can be done, my lord. My lord, only thing, interim order will continue, my lord, as per the order
Or
passed.
Mr. Arsake, learned counsel petition, Mr. and also Mr. Sharma,
Yes, DK Sharma, madam.
DK Sharma, learned counsel, correspondence. Mr. Arsake, learned counsel to the petitioner. Press correspondence granted 3 weeks time to file affidavit in reply. Mr. DK Sharma, learned counsel to respond is is directed to furnish a copy of the guidelines. What guidelines is it? Guidelines for
Reconstitution,
of retail outlet,
madam.
retail outlet dealerships.
And
List
the
of the
private
topics.
respondent is also not contesting the case, my lord.
Huh?
Despite the justice service, my lord.
None appears.
That is helpful for him.
None appears for the respondent number
4, my lord.
Four. But
Respect
notice
for-
has duly served upon him.
respect service of notice.
My lord, may I pray a fixed date after 3 weeks, my lord?
You choose a date.
My lord. On 22nd, my lord,
22nd
April.
April. 3 weeks.
Mm.
22nd.
Well, interim order may continue, my lord.
Interim order first and then shall continue.
Obliged.
What about 12?
May it please, Your Honor.
Yes.
Lordship, this is regarding compensation, Lordship.
Of what?
In this matter, Lordship, respondent number 1 to 10 are not yet filed your counter affidavit, Lordship.
Who is respondent number 4? 6 to 9.
6 to 9 government Lordship. 6 to 8 government Lordship and 9 land department Lordship.
Yes.
My lordship, we need some more time, my lordship. At least 2 weeks.
What is the matter?
Compensation.
matter is regarding, in fact, during the time of assessment, the land of the property of the petitioner, it was not assessed because it goes beyond the right of way. So in the process of this construction, construction, due to art cutting, his soil got loosened and the structure extending over there now has this developed cracks. So there was reassessment, seeking compensation. There was a reassessment. You have been paid reassessment of 28 lakhs. Yes. Something.
Yes, Lordship.
But then you have paid
Site
5
verification
lakhs
of-
only.
Site verification of the properties land was already done, Lordship.
You have been paid some amount.
Yes, Lordship, I had to be paid compensation an amount of rupees 27 lakhs.
27 lakhs. You have been
But-
paid only 5 lakhs.
5 lakhs, Lordship, 75,000.
So you want that it should be, you should be paid 27 lakhs.
Yes, Lordship.
If at all it has. According to them, there was an assessment. After that. So the assessing authority. Is who? Let them,
We'll be filing, my lordship.
Mr. D. Lord, counsel for the petition. Miss K. Wong, MSK Wong, London counsel appearing for state respondent, London
Yes, sir.
state counsel.
6, 7, 8, and 9.
Respondent, appearing for respondent number 6 to 9. Praise for is granted 3 weeks time to file affidavit in office. The London standing counsel for land management present.
Item number 15.
Me please, your lord.
Sir, what is to be done? What is this?
My lord, matter pertaining to claiming the ex gratia. The state respondent has already filed affidavit in opposition, but
Union of India has not.
Union of India is not yet to file. So,
Who is Union of India?
Union of India is CGSC, my lord. CGSC, learned brother M. Kato.
You are claiming for?
I'm claiming for ex gratia.
Ex gratia.
Yes, my husband sacrificed in the operation of Rocksock.
What is your stand?
Lordship, he is not eligible for ex gratia because this ex gratia it does not operate in a retrospective way. It was only in 2000 something only this was introduced for state of Arunachal Pradesh. So whatever happened, it was beyond in that, Lordship. In our affidavit.
What if the central government?
Central government, Lordship, we don't know. Because whatever they have given, it's of the state government only.
Lordship, I may be given some time that I to file rejoinder in affidavit of the state government affidavit.
Lord Mr. Udeka, learned counsel for the petition, also listed. I read up learned addition senior government advocate. Mr. Udeka, learned counsel for the petition, submits that is praised for and is granted 2 weeks time to 2 weeks time to
Yes, my lord.
file affidavit declare to the affidavit of opposition filed
Yes.
by the state respondents. Whatever, are you claiming any against grievance against the Union of India?
Yes, my lord. There is grievance.
Not appears for the Union of India.
Yes.
Are you appearing? Union of India. You are for
I'm appearing for M. Kato.
Mr. So-and-so learned, you just delete the last one, huh? Mr. M. So-and-so learned counsel to the petition. Appears on behalf of Mr. M. Kato. Learned. He's there. Then delete it. Mr. M. Kato is also permitted to file, is granted 2 weeks, is also granted 2 weeks time to file affidavit in office. It's a payment of claim of ex gratia.
Ex gratia, my lord, basically it will be liable to be paid by the state government.
You find it out, you file your affidavit. The state government is saying that this has been introduced, scheme has been introduced after that it doesn't have a retrospective effect. There is the state. You also file, whatever. Just after 2 weeks.
Okay.
Item number 16.
Your Lordship, the matter is related to non-issuance of NOC to start nurse course and paramedical courses.
Yes.
Your Honor, standing council, this may be matter may be adjourned, Your Honor, since standing council for health is not in this session, Your Honor.
Is there urgency? You have mentioned the matter for
Yes,
this.
Your Lordship, they are precising us because they want to start the courses. And they
Who's
have
pres-
issued
Who is
Your Lordship,
pressurizing you?
the university, Your Lordship.
Okay. Well, he said London Standing Council is not there.
Sir-
Do you have anything to say? You are appearing for? What is to be done?
Your Lordship, they have issued the NOC this in 2023 only,
Yes.
recently. But in that NOC, they have mentioned some condition for 20 intake only, the borders of 20 intake.
Yes.
So we have a problem with that, Your Lordship. Why? Because they have issued many NOC in this last 5 years because we have filed the RTI, and from that we came to know regarding the NOC also. They have issued the NOC, but we haven't received till date, but we came to know through the RTI, Your Lordship.
Yes.
So in that RTI, we have seen that they have issued five NOC to the university, to many different university. And in those university, they didn't mention about that point regarding the students.
What is the requirements?
Sir, 60.
60.
Yes, sir. The requirement is 60, but they have mentioned for 20 intake for every, like we can take only 20 students every year. So here, why we are thinking, why we are here, that we are thinking that they are doing discrimination to us because they didn't mention anything like this point to any of the NOC, which they have provided, issued to many university, Your Lordship.
It's the same year.
Yes, Your Lordship.
Same year and different year.
So, some are same years and some are different years.
Suppose you have been given 20 intake this year.
Yes, Your Lordship.
Other institute has also been given
No, Your Lordship.
15 or 20 or
They didn't mention
25.
anything like that, Your Lordship, in their NOC. I have mentioned, I have addressed that in my the recent affidavit, Your Lordship. We have submitted in the recent affidavit. So, Your Lordship, in this, you may see from the page number 10. So, in this no objection certificate, they didn't mention anything regarding the intake of 20 students. But in our NOC, they have mentioned.
No, why we'd like to know why 20? What is the reason for that?
Yes, Your Lordship, that's we want to know, Your Lordship.
Okay.
There's no reason they have given.
If you want to know, then you find the RTI. What is the reason?
But Your Lordship, since this matter is already here and they have issued.
No, we will allow you to file an RTI. No issue. We'll close this matter.
No, Your
With the
Lordship.
liberty to file and approach the authority by filing RTI.
But Your Lordship, we want the answer. Like, since this matter is here.
Problem is your friend is not there.
Yes, Your Lordship, they can take some other date.
So in that case, we'll impose a cost because it
Yes,
has been,
Your
it
Lordship.
has been-
Yes, Your
it has been listed
Yes, Your Lordship.
on your mention. So you are asking for an adjournment so that.
No, Your Lordship,
we'll-
I'm not asking. I'm here. And that's why I'm arguing about this on the subject, Your Lordship.
Okay. And MS so learned counsel for the petitioner. Mr. Iriram, learned additional senior government APS correspondent one. Mr. So learned counsel appearing on behalf of Mr. T. Tagum, learned counsel, learned standing counsel for Health Department. Submits that Mr. T. Tagum is indisposed today, for which he pressed for listing the matter after 3 weeks.
Okay, Your Lordship. Highly obliged.
Affidavit has been filed? No.
Yes, sir. It is there, Your Lordship.
So what is this? There is 10.
Sorry, sir.
What is the stand of the health department?
Oh, they didn't file the
Okay,
affidavit from their
that's the
side.
reason.
Yeah,
It's up to 2 weeks.
highly obliged.
Lordship,
Nothing survived.
yes, Lordship, that is instructed by my client.
You don't want
I
to
want to
press.
withdraw this, Lordship.
Mr. G. Kato, learned counsel for the petitioner submits that on instruction, he would not like to press the present writ petition. Mr. L. Learning, standing counsel for
Power Department.
Power Department present, recording the
And Lordship, it
writ
is,
petition stands closed on not being pressed.
Lordship, at the same time, this liberty to file this if necessary, Lordship.
In that case, you will have to change. You are withdrawing it.
Yes, Lordship.
Then you delete all that. So and so, then counsel phrase for withdrawal of this president with the liberty to file a fresh list of Mr. L. Penso and so present, The prayer of the learned counsel petition is allowed. Mr. Accordingly, the petition stands closed on withdrawal with the liberty as prayed for.
Item number 20.
Here I am praying some more time, my lord, to file everything opposition. I am corresponding.
According to them,
My lord.
have you seen this
My lord.
judgment order?
My lord.
It's a similar matter.
No, my lord.
But I
My lord.
beg to differ this judgment.
My lord, I have been.
No. This judgment passed by coordinate bench.
No, my lord.
This is this. Get this and go through. Last occasion, Mr. Tara vehemently submitted that it should be, this matter should be disposed on the same line. But this court,
Lord, here in this
you
case,
find it out.
yes, my lord. Yeah, yes, my lord. I appear in this case, my lord. I appear, my lord.
Man has retired.
My lord.
He has accepted the promotion after retirement.
Well.
You are claiming that you should have been promoted from the date of officiating or in charge.
Well.
And he said this court has allowed. We'll consider and we'll refer it to larger bench.
Here, my lord, in the particular case, my lord, I need some.
You get hold of that judgment and read it. Come back. We'll grant you today. We'll grant you a time today, but take that, take out that judgment and go through that. Which this court is not agreement with that judgment. So we'll have to pass a reason order, and then it has to be referred to larger bench. Placed before the Chief Justice. What do you say? Can it be done? Suppose you have been allowed to hold the in charge or officiating whatever, and DPC held after 10 years, and then you retired, you accepted the promotion and all those things from the date of DPC, and after retirement you suddenly said that I should have been given from that day. One could understand on the facts of those cases, if a person is continuing in the service after retirement, why? And you have accepted this.
In this particular
And
case,
by this judgment, this prayer has been allowed. Which this court
therefore, my lord, I believe, my lord, reconsideration, my lord.
respectfully don't agree.
Review the DPC, my lord. Has been allowed, my lord.
That cannot be. Why?
Review the DPC only, my lord.
There is not permissible under the law. In view of opinion of this court. Anyway, heard Mr. So-and-so, petition. Mr. L. Perme, London Standing Counsel for Agriculture.
My lord.
Department. pressed for and granted 3 weeks time to file affidavit.
My lord.
You inform your senior, Mr. Tara. This court is not in agreement with this judgment.
Okay.
We'll decide this and then refer the matter to larger bench.
Okay.
In case if it comes back to this court.
Always.
This after 3 weeks.
Much of it.
Item number 21.
Yes.
Lordship, we will be needing time because only today we have received the extra copies.
What is the matter, madam?
It is a matter of compassionate appointment.
Yes. What is the scheme? Do you have the scheme?
No, Lordship, we have not because different, of course, there is same policy, but the different have departments have their own that one method.
Do you have the scheme? As a whole?
As a whole, Lordship, we don't have.
They are saying that there is a 2001 instruction for compassionate appointment. Notice has been issued.
Notice issued, Lordship.
Long time back. September 2009.
Lordship. Only today they have given the extra copies.
MS. So and so learned counsel for the petition. Next paragraph. The issue involved in the present writ petition is for appointment on any group D, group C or D post on compassionate ground. Please stop. It is noticed that this court has issued notice to the respondent on 29/9/2022. Mr. I. Ramlan, the Assistant Senior Government Advocate, submits that since the extra copies have been furnished to him only today, i.e. 01/04/2024. Come on. He may be granted 3 weeks time to obtain instruction and file affidavit in opposition. List of prayer is allowed. List this matter after 2 weeks so as to enable Mr. I. Ramlan, recent senior government advocate, to file affidavit in opposition on or before the next date of listing, as the issue relates to appointment on compassionate, prayer for appointment on compassionate ground. You file it before that, right? There is a judgment of the High Court, full bench also. How it is to be, what should be the procedure. And in fact, in scheme, under the scheme, it is already provided. So you find out all those things and act on it.
Item number 23.
What is to be done, madam? What is
Your
the?
Lordship, respondent number one have to file affidavit. Okay.
What is the matter?
It's adoption matter. Adoption.
Adoption.
Yes, Your Lordship.
So far, we have not received instruction from the respondent number one, madam. And madam, whether the affidavit on the part of the respondent number one will be required or not, madam, we can. So in that case, madam, some more time may be granted, madam. I'll take instructions from the department whether the affidavit of the respondent number one will be required or not. Adoption, madam, for adoption, there is a separate guideline, madam. The adoption, law of adoption is there, madam.
Administration learning consequence. Mr. M. Kato learned DSGI appearing on behalf of respondent number one. 1 and 2.
Thank you.
Respondent is granted 3 weeks time to file affidavit of police. You are for?
One, madam.
Yes.
Madam.
R. Basir, the State Council for respondent number one. District Child Welfare Committee, you are not representing. No. Have you taken steps for
Yes.
3 and 4?
Three
3 and
three
4, State Council for 3 and 4 present. And what about 5, 6, 7?
5, 6, 7. We already,
5, 6, I'm sorry. 5,
We-
6.
we already served them.
Okay. Doesn't show anything whether you have taken steps or not. It's okay. List after
4 weeks, madam.
4 weeks. We have granted 4 weeks or 3 weeks?
2 weeks.
You
4
want
weeks
4
time.
weeks? Then make it granted 4 weeks. List after 4 weeks.
Madam. The privilege.
Much.
Item number 25.
My lord. My lord, as per my client instruction, I want to withdraw this matter.
You went to withdraw.
Well, withdraw this matter.
Mr. So-and-so learned counsel for the petitioner submits the. He may be allowed to withdraw this present, this writ petition. Mr. MS. K. Wong, learned state council present. The prayer for learned council petition is allowed. Mr. Accordingly, the writ petition stands disposed of on withdrawal. Yes, ma'am.
Item number 26.
Please, Your Lordship.
Yes.
My lord, in this matter, except for respondents 4, 6, and 9, other respondents have not filed affidavit.
Okay.
More particularly, respondents 2 and 3's affidavit would be needed
Is needed.
in view of the issues involved.
So who is representing them?
Mr. Kamduk, Land Department.
Where is Mr. Kamduk?
He was here a while ago.
In that case, MS Endang, learned counsel for the petitioners. Also,
P.
Ms.
Sangeeta.
MS P. Sangeeta, state
For
counsel,
five,
learned state counsel for respondent number
5 to 9.
5 to 9.
Yes.
Then, whose affidavit is required?
2 and 3, Lordship,
2 and 3.
Land Department.
MS Endang, learned counsel for the petitioner submits that in view of the nature of the grievance raised in writ petition, the affidavit in opposition of on behalf of respondent number 2 and 3 would be required, Mr.
Bearing on behalf of Land Standing Council, Peter.
Peter Paul. Okay, you record mark his presence. None appears, none represented the respondent number 2 and 3. Mr. However, it is stated at the bar that respondent 2 and 3 are being represented by Mr. D. Kamdal, Standing Council for Land Management Department. Mr. Therefore, not therefore, Mr. In view of the Mr. D. Kamdug is directed to file affidavit in opposition within 3 weeks.
Lordship, there is an interim order.
Huh?
Interim order.
Oh, interim order first, earlier shall continue.
Obliged.
Interim is for this is for what? Compensation?
No, Lordship. Allotment, Lordship.
Allotment.
Yes. Obliged.
Item number 27.
Yeah, Lordship.
Yes.
Lordship, I'm for the respondent number 4, my lord.
Yes.
Lordship, I may be allowed 4 weeks time to file affidavit in opposition, my lord.
Heard Mr. So-and-so, learned counsel for the Mr.
And Noble.
And now learned counsel appearing on behalf of Mr. Respondent number 4 is granted 3 weeks time to file affidavit in opposition. Ms. P. Pango, learned state counsel present. Have you filed the affidavit?
Yes, sir. So 1, 2, 3. Obliged, sir.
Item number 28.
None appears for petitioner on call, and none appears for the parties on call. List after 4 weeks.
Item number 30.
May I, Your Lordship? Item 30 was adjourned in the morning, Your Lordship. By the
30.
petitioner, Your Lordship.
Item 30,
Yes, Your Lordship.
adjourned.
By not by our petitioner, Your Lordship.
You check it. If not, you just non appears for the petition list is matter after 4 weeks. Huh? If it is adjourned, okay, otherwise non appears for the petition. Okay.
Item number 31.
May I, Lordship?
Yes.
Lordship, I'm extremely sorry that as per last order, I haven't taken the step.
Mr. So-and-so, learned counsel for the petitioner
Allow me to take
is permitted
precise
to
step.
take precise steps for respondent number 1 and 2.
My Lord, Dusty as well as register post.
As well as the state within 2 days. Yes, after 3 weeks.
Much obliged.
Item number 32.
May I please, madam?
Yes.
Here the respondents are yet to file affidavit, madam. But madam, this is a matter, is a serious matter, madam.
Yes.
So, madam, on the next day, if they don't file the affidavit, madam, my interim prayer may be considered, madam.
What is your interim prayer?
My lord, to state the matter, impugn order, my lord, at page 65, my lord.
Page 55.
65, madam.
Yes.
This is by the Deputy Commissioner to the Deputy Registrar General, Office of the Director Census.
Freezing of boundaries of administrative unit.
Regarding change in administrative boundary in respect of the district Dibang Valley, in reference to letter number such and such Shillong, regarding freezing of boundaries of administrative unit, the undersigned would like to submit that the finalized list of the villages are to be merged back to this mother village as per required format. My lord, and it has been merged with my lord, page 66, my lord.
It's okay, we'll consider next date, but then you have also not taken steps for respond number 8. And you also file affidavit.
We'll take steps by
Oh.
this, my lord.
Or Mr. Arsake, London Council Police. Office note dated 3003/2024 reflects that petitioner has not taken steps for service of notice after respond number 8. Mr. The London Council for the petitioner is permitted to take steps for service of notice after respond number 8 within 3 days. MS Kewang London State Council is also is granted 3 weeks time to file affidavit of petition. Are you appearing?
My lord, I'm for the
Mr.
respondent number 4, man. Our
Central
affidavit
government,
may
central
not be
government,
required into the
central government.
Central government.
The M Kato for the land is DSGI for.
In fact, they have directed for
General
ministerial inquiry, my lord, to the Deputy Commissioner, which the Deputy Commissioner has not done. Instead of inquiring, ministerial inquiry, they have transferred our, my lord, land to another village, my lord.
Item number 33.
33 mentioned. 33 mentioned.
But here,
Mr. Or Mr. M. Kato, Land Council for the petitioner, huh?
Mine.
Service report in respect of restaurant for is awaited. List after 3 weeks.
Item number 34.
May I please, Your Lordship?
Yes.
Your Lordship, we are yet to find, yet to receive our extra copies, Your Lordship.
When the notice was issued,
Notice was issued on.
October.
Yes, Your
Last
Lordship.
year.
Yes, Your Lordship.
You were waiting for the extra copy.
Yes, Your Lordship.
None appears for the petitioner on call. MS P. Sangita, London State Council present. It's after 4 weeks.
Okay.
We'll see. It's okay.